next week, just so you guys know, we're going to be working on the unemployment bill that the House sent over, 2197. We're probably going to block off the whole week. What we're going to do on Monday is we're going to have an overview of everything they did, every amendment, and then we'll probably hear testimony on Tuesday, probably start working the bill on Wednesday. So if you got amendments, get them ready. And then we might hear from some more testimony and then try to get it finished by Friday, Thursday or Friday. So, we're going to, after amendments, we'll allow some questions to be asked. That way, we're trying to get the perfect product or the best product we can from each side. It'll be a little different than the normal bill. So just giving everybody a heads up, because we've already heard the original version, and then there's been about 20 amendments put on it. So 22 amendments, okay. Thank you. So we'll start off. Chuck, we'll go ahead and open the hearing on Senate Bill 219. This is a bill that we had it scheduled, and we had 3 bills that day, and somehow we kind of got mixed up and didn't do it. So we asked this bill to get blessed. This is a bill we'll probably try to work Monday or Tuesday next week to get it on the agenda, to get it moving forward, because I messed up and didn't get it out before turnaround. Go ahead, Chuck, and Senator Tyson, go ahead.
So just a question for point of order. So this is an informational hearing then on the bill, or?
No, it's been blessed.
Oh, okay.
Oh, it's been blessed.
Okay, great.
I asked leadership and they sent it to Fed and State, bless the bill, so it's a live bill. Yeah. Chuck, go ahead and give us an overview on 219.
Okay, thank you, Chairman, members of the committee. Senate Bill 219 deals with activities that require a license by the Kansas Real Estate Commission, activities as a broker, a real estate broker. And the first thing the bill does is it adds an activity that requires licensure as a broker, and that is engaging in a pattern of business of buying or selling contracts, including assignable contracts for the purchase or sale of or options on real estate or improvements on real estate. And you'll see throughout the bill there is additions made with respect to business entities, and the bill seeks to make the restrictions on activities and the licensing provisions of the applicable to a real estate broker also applicable to employees or principals of these business entities. So with respect to employees or principals of a business entity, there's a pattern of business. You're restricted from engaging in a pattern of business that, again, would be the business of buying or selling contracts. And that pattern of business is defined as engaging in one or more of the practices listed on 2 or more occasions in a year. That's on page 2 of the bill. The bill also adds language that provides that actions prohibited unless licensed as a broker or salesperson may not be conducted by a person as an employee or principal of a business entity. And that, of course, is an owner or an officer or a partner or employee. That's on page 3. With respect to exceptions from licensure requirements that are in current law, the bill adds that there is no exception for engaging in a pattern of business of buying, selling, or otherwise dealing in assignable contracts for the purchase or sale of options on real estate or improvements on real estate. And again, the definition of pattern of business is engaging in one or more of the practices listed on 2 or more occasions in a year. This limitation also applies to the current exception for the sale or lease of real estate by an employee of a business entity which owns or leases the real estate if the employee owns a 5% or greater interest in the business entity. So that is a current exception in the law, and the language that I've discussed with regards to the prohibition on a pattern of business applies with respect to that current exception. The bill also does a couple of things with respect to the Real Estate Commission, expands their authority. Number one, they now have authority to issue an administrative fine after notice and an opportunity to be heard against a person or business entity. And that's a kind of a key addition there, or a business entity, for a violation committed by an employee or principal in an amount not to exceed $1,000 per violation. The commission is also granted subpoena authority for testimony, production of documents, and the district court is granted jurisdiction to issue orders enforcing those subpoenas or revoking or modifying them. And that is what the bill does.
Questions for Chuck? Senator Peck?
Thank you, Mr. Chairman. So a person who flips houses, they may flip a dozen of them in a year or more, this would not affect them at all, or would it?
With respect, Senator, with respect to actions by individuals, the bill really doesn't change the licensing requirements under current law. What the bill does is making sure that those restrictions apply to employees or principals of a business entity. And then there is a language about engaging in a pattern. So you can't do these specified actions. You can't engage in a pattern of doing those specified actions, either as a business or as an individual. And the way that the commission is going to regulate businesses in this regard is through the individuals, the principals or the employees who make up that business. So with respect to what an individual can do, there really is not a change in this bill other than what an individual can do as part of a business. And the bill makes sure to cover those kind of actions.
We'll potentially hear maybe from the Real Estate Commission or something, but
We will. They're first step. Senator Holland?
Thank you, Mr. Chairman. Hey, Charles, just a quick question on the bill. Obviously, it looks like this wholesaling issue is trying to be addressed in here, but are these contents at all similar to maybe what was laying around from last year that we never got pushed out?
I think this is primarily new, Senator. I didn't look and try and see if there was a bill that was substantially similar to this. It didn't strike me in looking at this that it was something that we had heard before, but there have been bills sort of like this, I guess, maybe not exactly like this. And so I'm sorry, I guess.
No, Charles, that's fine. I just couldn't recall. I thought we had last year some legislation on behalf of the real estate folks, and I couldn't remember if that actually got put into law or if that just languished over, and this was basically a revival of that. Thank you.
Okay, further questions? Not seeing anything, Chuck. The fiscal notes in front of the bill in the back of the packet. We'll go ahead and go to proponents. Eric Weisner, Kansas Real Estate Commission.
Good morning, Chairman Olson and members of the committee. My name is Eric Weisner. I'm the Executive Director of the Kansas Real Estate Commission. On behalf of the Commission, thank you for the opportunity to present testimony in support of Senate Bill 219. So KREC's mission is to protect the public interest in the selling, buying, and leasing of real estate. We do this through licensing salespersons and brokers who transact real estate in the state of Kansas. This legislation is designed to close a possible loophole in Kansas real estate licensing law that allows unlicensed individuals who don't own the real estate they are marketing or attempting to sell to perform services that resemble or even identical to services provided by Kansas real estate licensees. So with respect to Senator Peck's question on house flippers, this would not impact them because they actually purchase the home, make some modifications, and sell it. This doesn't impact that activity at all. So what the bill would do is prohibit a pattern of business where an individual attempts to sell what's called an equitable interest in a contract for the purchase of real estate that they do not own 2 or more times in a 12-month period without holding an active Kansas real estate license. Some states have taken to actually prohibiting this practice. However, what this bill is designed to do is to basically say that instead of prohibiting it, it clarifies that if you do want to engage in this practice, that you need to obtain a Kansas license. So just a brief overview, because I think it would be helpful for the committee. So what is assigning an equitable interest? So basically, the practice of assigning an equitable interest, which is also known as wholesaling, occurs when an individual enters into a contract to purchase real estate. So they approach, somebody who wants to sell their property, and then they, do this, sometimes 1-2-page contract, and then they immediately, before they don't actually purchase the property, they basically try to attempt to resell their interest in that real estate to another buyer prior to closing or taking ownership of the property. These wholesalers don't have any intention of actually purchasing a property or ever taking title to the property. If the wholesaler can't find anybody to sell the contract to, what they'll typically do is back out of the contract prior to closing. Most of the time, they structure these contracts so that they owe minimal or no earnest money to the seller. A lot of the ones I've seen, it's usually $10 or something really, really small. These wholesalers, in the attempt to sell their contract, will advertise the property as if they actually own it, which, if they actually did own it, they would be exempt. But they don't. They don't ever have a title or they never take ownership of the property. The Real Estate Commission feels like this is a consumer protection issue because these unlicensed individuals essentially, they act like real estate licensees, but they have no requirement to abide by the statutes of minimum duties and obligations that are set in law to protect sellers that they're working with or that a licensee would be working with. So some examples of this would be in Kansas law, licensees required to exercise reasonable care, skill and care, and account for all property received. In some of these equitable interest contracts, we see that there's provisions where the seller agrees to actually provide a lockbox with a code like you would if it was a standard real estate transaction, where the wholesaler or anyone the wholesaler gives the code to can access the property. In this case, if something was misappropriated from that property, there's really no protections for the seller like there would be if it was a licensee who did that action. And then in license law, there's basically the ability to file a complaint and for the commission to actually do an investigation and determine if the licensee did misuse property. In addition, there's in Kansas law, with respect to licensees, there's a requirement to disclose all adverse material facts known. So an example would be if the wholesaler, they enter into this contract, they find out as their title work is getting done, for an example, that there's an issue with the title, right? I've seen instances where they'll back out of the contract, but there's no requirement that they disclose the fact that there's something wrong with the title. So, the seller may not be aware of that, and if they want to continue to sell the property moving forward, they may not know that, whereas a licensee would be required to disclose that to their client they're representing. Again, this would not impact the exemption in Kansas license law for individuals who sell the property they personally own. So you've probably seen FSBOs, FSBOs for sale by owners. That exemption still exists. Obviously, people who flip houses, that still exists. Nothing in this bill affects that exemption. So again, in summary, the reason the commission feels this bill is necessary is it provides protection to consumers and accountability for buyers and sellers in real estate transactions. Oftentimes, the purchase of a home is the largest financial transaction someone will make, and nothing in this bill prohibits someone who does want to do wholesaling from doing that. They just are required to obtain a license through the commission. It clarifies that this is licensed activity. The reason why we feel that's necessary is it provides KREC oversight to investigate consumer complaints. We received 20 complaints last year related to wholesaling activities. And obviously it provides the avenue for the public to resolve disputes and claims that, otherwise would require them to enter into litigation, which is a lot more costly than filing a complaint with the Real Estate Commission. As Chuck mentioned, the commission is also requesting some reasonable powers to fully investigate unlicensed activity using the subpoena power, which we're proposing to do. That's Section 6 of the bill. And in addition, we're also requesting the ability to, when necessary, to issue cease and desist orders and administrative fines to stop unlicensed individuals from performing their activities. These proposed powers are very similar to what other agencies, boards, and commissions in Kansas have. I believe we've actually copied the language from some different boards. I know Behavioral Sciences, Board of Cosmetology, Board of Vet Examiners have very similar language. KREC has worked on this legislation with the Association of Realtors, and they're in support of that. So with that, I'll go ahead and close my comments and be happy to answer any questions that the committee has.
Let me make sure, because I'm in real estate. I buy a lot of real estate, sell a lot of real estate. I've seen a couple of these, I believe, where people are buying these on long-term contracts, and before they close, they actually have it listed and for sale. I've seen a few of these where you come in and they're trying to sell the property. Disclosure background is very shady normally. You don't get a lot of information with the property. That's what we're after of closing, right? That loophole that allows these, a lot of times I think they're on the MLS, some of these properties. So they're probably, some of them are real estate agents even doing this. I mean, we're going to close that loophole. That's what we're after in this bill. Is that right?
Senator, yes, that's correct. A lot of times, at least the complaints that the commission's received, the contracts are very, let's just say, minimal in nature, maybe 1-2 pages, which have there's very little detail. Obviously, there's no disclosures of minimum duties because these people aren't licensees, so they're not required to do that. However, they claim to use the exemption that they own the property, but they never take title to it. With respect to some of those properties being listed on MLS, I suppose that they could be. Usually, you can't list on an MLS. The commission doesn't have any jurisdiction over the MLS. That's a service provided by the usually local boards, Association of Realtors. But supposedly, if the person that's signing the contract is actually a licensee, then they could use the MLS to do that. And actually, moving forward, they could still do that because they have a license, so that would be an activity they could do. Now, the difference is we actually have the authority to take action against individuals, who are doing that now, versus we don't have authority to do anything for people that are unlicensed at this point.
Yeah, I just personally myself, I hate to see a real estate agent buy a piece of property and resell it. Someone in the middle, maybe they are doing a favor for someone that needs money or needs the situation resolved, but then to see them ask for, 20 or 30% increase. But I know the situation you're talking about, I've seen it a couple times. I don't remember how I've come across the property. If something come into my real estate agent, because normally I don't go without an agent anywhere, because I like to have the background, make sure there's no easements, all that stuff done. But Do we have any questions? Senator Straub.
Thank you, Mr. Chairman. So my question is, this is my understanding of what we've been presented here, is that it is the Real Estate Commission's opinion that people are acting as real estate agents when they are advertising a property for sale. Do we have actual cases, or can you provide examples of advertisers, not licensed real estate agents, advertising property as they actually own it? I mean, actual written documentation that they own the property, or are these simply consultants, advertisers, different kind of agencies that might be promoting a property for sale by owner? Are they actually claiming that they have ownership of the property? And if they did, that's legal, correct? What are they saying that is that's illegal? What are they claiming that is illegal? Are they claiming to be a licensed real estate agent and advertising property for sale? I feel like I'm missing something here.
You can go ahead. Go ahead.
Yeah, so Senator, that's a great question. They're not claiming that they're a licensee, these people that are wholesaling the property. What they are claiming is, and a lot of times they're posting Facebook and probably Craigslist are the areas where we see this most. They're posting on those platforms that they own the property that they're advertising for sale, and they usually frame it as something like, investors, come see this property. A lot of times it's distressed properties that they're doing this, and they'll say, I'm doing this, and then sometimes in the post, or sometimes they don't even put it in the post, they'll put it in the contract when they reach out to the investor. They'll say, I don't actually own this property, I'm just assigning my equitable interest to purchase the property. So what they're saying is, I have a agreement in place with the seller to purchase the property, but I want to sell it to you, this contract, and then what I'll do is I'll just take a fee for it, right? So, say if it's a $50,000 property, I'll pass it along to you to purchase. I'll just want the $2,000. But they initially market it as like that they own the property, but when they don't. And what we find is when we get complaints, it's the seller usually who'll say, hey, I thought this guy was purchasing my property, and he turned around and sold it to somebody else. The deal fell through. He canceled the contract, and now I'm stuck with having my property that I can't sell, or that I haven't sold yet, when I thought I was, entering into a contract for this person to purchase it.
Go ahead.
So these people aren't actually claiming to be licensed real estate agents, correct?
Yes, that's correct. In most cases, they're not advertising that they're licensed agents. What they are advertising, though, when they market the properties to investors, is that they actually own it when they don't. And therefore, in the Real Estate Commission's opinion, when you're essentially basically doing the same activities that you were as a broker. You're marketing the property that you don't own to someone else.
So an advertising firm, like say I have a friend who is trying to sell their house, and I'm an advertiser or consultant, and I post their property to Facebook saying, hey, come check out this property. I'm not saying I'm the licensed real estate agent or anything, but I'm helping them promote it. That's illegal.
In Kansas, that's Senator, that is an activity that requires a license. So
I see people do this all the time. I see many people share a friend's property that's listed for sale by owner. In fact, we have lots of different advertising platforms, online platforms like Next Tech Classifieds, where people will have a farm for sale or whatnot. We'll have people looking for properties for sale on there. And you don't have to be a licensed real estate agent to advertise those properties on there. How is that any different than what we're hearing here?
Well, so I think, and that's kind of where Senator, I think that's a good question. if it's just, and that's why in the bill it says 2 or more times in a 12-month period. If it's, while it is an unlicensed activity to advertise or market a property that you don't own, or there's also, if you're an employee of if it's a business entity that owns it and you're an employee and there's some exemptions there as well. That being said, if it's a one-off instance, that's not what this bill is trying to address. It's the people who basically do it as a business practice. So they consistently advertise or market property that they don't own. I can't speak to the example that you provided because I'm not aware of that function, but I do know that there are instances where we have seen people who forward on a Facebook post for somebody that's selling property, and we remind them that this is activity that requires a license, and they usually say, "Oh, I didn't know that. Sorry, I won't do it again." This is a different beast here, I think.
Go ahead.
Sorry for all the questions, but I have actually seen this both ways. I've seen licensed real estate agents post properties on Facebook, and I've also seen for sale by owner friends share properties that are for sale, and multiple times. So sharing the same property more than twice in 1 year is considered illegal activity, because I'd say on Nextech, you have to renew a listing every week. Each listing is only good for 1 week. I think this sounds like some overreach. I don't know. I'm looking for an actual example of a business or a company or an individual who is somehow frauding the system and is not a licensed real estate agent that's claiming to be.
Well, Senator, I don't know if I can give you an example where they're claiming to be an agent, but what the issue is they're advertising property as if they own it, when all they're doing is basically entering into a contract to buy this property. And from the commission's perspective, the consumer protection issue is that the seller thinks that that this is, they may not realize that they may think they're dealing with an agent, or they may think they're actually dealing with somebody that wants to buy the property. But the intention is, all they want to do is basically sell it to somebody else, collect a finder's fee or whatever it's called, and move on with it. And if they can't do that within the amount of time in the contract, they just back out of the deal. And we feel that is from the commission's perspective, that's where it's a consumer protection issue, and that's why we want to close the loophole.
Okay. Go ahead, one more question, then we'll.
Sorry, not to keep beating this, but if the seller signs a contract with someone and they have not fully vetted that person, and if they don't have a contract in hand that says that person is a licensed real estate agent, then I feel like the responsibility is on that seller to make sure that they're dealing with a licensed real estate agent. Because you could deal with any kind of advertising firm, consulting firm, friend, whoever. If somebody's not falsely claiming to be a real estate agent, then I don't see where the fraud is here.
Senator, I think that the difference between the instance that I'm referring to and just having a friend share a post is that, in that case, that seller clearly knows they're not selling the property to the friend. They know the friend is, not an agent that's marketing the property. Where in this case, the seller actually thinks that this person is purchasing the property, and don't realize that purchase is contingent on them, basically transferring the contract to somebody else. I think that the for sale by owner exemption is because it's not really commerce. It's transferring one entity directly to another. Whereas in this case, there's basically this wholesaler serving as a middleman, yet there's, nothing that they basically have no, at least from a consumer protection aspect, there's no requirements for disclosure and things like that would exist if the licensee was involved in that transaction.
Senator Holland. You can go ahead and then,
Thank you, Mr. Chairman. So I have some real concerns now about, let's talk about the seller's rights here. What is contractually, what is the seller being presented when one of these wholesalers approaches the seller? What is in that agreement?
Senator, that's a good question. I mean, it's all over the map. Sometimes I've seen these contracts where it's literally two lines where they basically say, I'm going to purchase this property for this price, at this location, at this price, and by this date, and I'm going to assign the contract. And if I don't, then I can close or I can back out by paying $10 or nothing. See, we've seen some other ones where they go into a little bit more detail, but they don't ever.
So they may or may not reveal that they're a wholesaler, correct?
Some cases we've seen where they have not, yes, that's correct.
Okay, so you have sellers out there that think they've actually agreed to a legitimate deal. They perceive they know who the buyer is, and that is not clearly the case. It's being declared in the legal documents.
And then in some cases, it seems like it's blatant because in some of the contracts, everything's in the same font, and then the fact that maybe they are assigning the contract will be in a smaller font, so it'll be actually, why would you put it in a smaller font unless you didn't want somebody to read it?
a lot of times, I've seen one of these, I know for sure. And it was just a handwritten document. It's like something you'd pick up at Office Max or kind of contract.
I guess where I'm going with this, Mr. Chairman, is that I see a lot of problems with basically ensuring the integrity of these types of business transactions. And I'm also wondering just the whole liability issue that opens up. Because if someone has made some misrepresentations to the seller, that yes, I intend to buy this, and now in the meantime, that supposed buyer is now trotting around trying to find somebody to buy the property, I assume that basically that wholesaler now is going to bring potential buyers to him onto that property. And so now you have liability issues of where you have a seller who now unknowingly to them, they actually have the public traipsing into their property, right, doing property. I mean, it could be they could be calling in third party to do property inspections, correct? I mean, you have a whole gamut of things here. I mean, basically you have this wholesaler acting like a realtor, yet the seller doesn't realize the scam, and the potential buyers don't realize the scam. Assuming in these, there isn't necessarily no duty, is there, for these wholesalers to be revealing to the buyer that they in fact, I guess my point is that this to me just totally guts to me why we would have realtors and licenses. I mean, it's kind of like if I wanted to sell securities for a friend, it's like, well, I'm just going to do it this once. I don't need a license. To me, there's a whole bunch of, I guess to me, there's a whole bunch of problems here why you even want to let this happen just once. To my mind, if you're talking about people who are making money in this transaction, why you would let that happen just once, I don't understand.
Senator, I mean, from the commission's perspective, I think you bring up a good point. Yeah, there's definitely, information asymmetry between people who, are selling a home versus people who have expertise in the real estate industry. However, I think from the commission's perspective, this was I don't want to say a compromise, but a middle ground to say, we're not going to propose banning this practice. And as I mentioned in my testimony, some states have kind of gone as far as to do that. Instead, what we're saying is that, this is a licensed activity, and because you're required to have a license to do this, then you fall under the laws and regulations that require, minimum duties, that I mentioned in my testimony, exercising reasonable care and skill, accounting for all property, disclosing any adverse material defects that you're aware of. So,
but I mean, wouldn't you agree, in effect, they're acting as a realtor?
What I would say is the wholesalers are conducting activities very similar to what a licensed, a Kansas licensee would be doing. especially when it comes to marketing the property and things like that.
I'm just really struggling with, if you're going to regulate this, I think you need to shut it down entirely. Otherwise, I don't know why you go to the trouble, basically, to have realtors' licenses. That's where I'm at, and maybe I'm oversimplifying it, but I see a lot of problems with what this wholesalers could create for both the sellers as well as these buyers. And to let this stuff run unamuck, I don't understand that. To me, somehow a friend for free advertising something, I could care less. But I mean, these guys are, I would call these wholesalers, sounds like they're pre-flippers. Okay. And if that's where we're going, I have a lot of concerns about both our sellers and our buyers in the future. Thank you, Mr. Chairman.
Yeah, I think what they are to me are they're people that don't have the money to flip. They're able to go out and what they're doing, they're getting a contract from someone to purchase that they never intend on closing on unless they sell it. Now, I think where the fraud could be is, I mean, if you get an individual, say you're buying a house for $50,000, you write that check, $50,000 check, he's still got to go pay the other individual. I think there's a lot of disclosures now. I mean, is he disclosing that this is a cash deal or, often when you sell property, there's a disclosure agreement that's pretty lengthy that you got to fill out, a lot of history. And so how is this person disclosing that the guy he bought it from had a disclosure, there was an inspection within a year? There's stuff he might not be disclosing that the prior owner disclosed, so I don't know. Senator Holscher.
Thank you, Mr. Chair. Just one question. You alluded to and kind of touched upon that there were 20 complaints last year, and you talked a little bit about that. Can you expound a little bit as far as what type of complaints those were, if any similarity in nature, and then are we talking monetary loss as a result of those or fees other than obviously lost time on the part of the seller who thought something was going to manifest and potentially it did?
Senator, yes, that's a great question. So I would say they kind of fall under two different categories that we usually see. One is a complaint that actually comes from someone who genuinely thought that this person was going to buy the property. They and then they backed out, or they didn't realize that they weren't, they were just trying to assign the contract. And then the other would be from most likely other licensees who are saying this person is out there advertising that they have property for sale, and they are, they don't own the property, or, they're marketing somebody else's property without a real estate license. So that's usually the two ways we get those complaints. And right now, we don't really have any authority to do anything against those individuals, other than just tell them that we send them a letter saying you may be in violation of our license law, and provide them the statute. And that's essentially it. And I did want to mention, this is the Commission's attempt to address what we perceive as a consumer protection issue, and we're definitely open to, working on this and improving it. We just want to make sure, our responsibility is to protect the public, and we want to make sure that we're doing that. And we see that this could be, or has been a consumer protection issue. So that's why we're bringing the legislation.
Do we have a follow-up question? You're good. Senator Stephan.
Thank you, Chairman. Could you send us or give us a list of 3 to 5, concrete examples when a seller or a potential buyer were harmed from this?
Yeah, I could go through and give you some examples of complaints that we've had where the consumer has done that.
And more than just hurt feelings, but actual concrete monetary losses.
I don't know. I think concrete monetary losses, it may not be that they lost money directly, but they thought that they were marketing the property and they needed to sell it. And the fact that they they thought they had a deal in place to sell the property and they backed out and they didn't get any earnest money or got $10 for it, I think that's where they feel like they've been negatively impacted financially.
Thank you. It sounds like a great educational opportunity for the board and for the realtor associations to me. It doesn't sound like a great spot for a law.
Senator Peck?
Thank you, Mr. Chairman. Looking at the fiscal note, I had a question on the last two paragraphs, just to sum those up. It looks like passage of this legislation, according to the Attorney General's office, could create additional litigation, including constitutional challenge to the legislation. Can you address that? How is that valid, and what would they sue on, and why would anyone think it's unconstitutional?
You would probably have to ask the Attorney General's office that question. They're the ones that submitted the fiscal note. I've had a brief conversation, and they said that the thought was that there's potential that an unregulated person could file suit challenging the law was basically all I got. But you'd have to ask the Attorney General on that. I would note that this bill, the bill that was the commission presented or requested introduction of, we do have our legal counsel, both general counsel and disciplinary counsels provided by the AG's office, and they did assist with drafting this bill. So but you'd have to ask the Attorney General on why they put that in the fiscal note.
I mention that, Mr. Chairman, because I don't regularly see where the Attorney General's office has weighed in saying passage of this legislation is likely to increase litigation. Thank you.
Okay. One quick question, and we're going to get on to the next proponent.
Real quick, Mr. Chairman, thank you. So speaking of Attorney General, he does have a consumer protection group. Have you just asked them how they would like to see this addressed? If they see this as a risk, and how to go about if they perceive it as being such?
Senator, have not directly asked the Attorney General's office if they perceive it as a consumer protection issue, or if they want to have that within their purview. But I think the thought is that this is an attempt to have the real estate commission be the ones to review complaints and have jurisdiction over this, because our investigators are subject matter experts, so to speak, when it comes to real estate transactions and responsibilities that licensees have to their customers and clients.
I would just cabbage on to Senator Peck's comments, if I understood him correctly. I'd like to know specifically why they think the bill would increase the workload. Thank you.
Okay, we can ask, probably ought to ask the budget director too. I mean, he's the one that made the comment, but we can ask the Attorney General's office. Let's go ahead and move on to Mark Toom, Kansas Association of Realtors.
Chairman Olson, members of the Senate Commerce Committee, thanks for the opportunity to provide testimony in support of Senate Bill 219. My name is Mark Toom. I'm here on behalf of the Kansas Association of Realtors, and first and foremost, CAR is supportive of this legislation because it would benefit consumers. And we all know that a home is generally someone's largest purchase, and this bill gives, I think, reasonable investigative powers to the Kansas Real Estate Commission in order to better protect consumers from potentially fraudulent activities. Kansas law exists right now to protect consumers in real estate transactions, and having real estate transactions handled competently dictates certain practices. Practices are being deployed that I think escape oversight and have the potential to erode consumer trust in that process. And I think the ability to investigate is important to halt some of those activities. And I'm going to be very brief and be happy to answer any of your questions.
Okay, do we have questions, Mark? Senator Tyson. I waited a little while.
No, you're fine, and I was
Get Mark a couple
hesitant.
questions.
Thank you. I see why you're, well, I don't see why you're concerned, but my question is, we keep seeing advertising on real estate theft, on Register of Deeds and that type. Wouldn't that be more prudent or productive for the real estate owner than something like this?
Thinking like title theft and such, I mean, certainly a concern, and I'm not aware of a legislative solution in that area, and I'm not sure how, I think there's still some marketing that's occurring in that area, but I'm not sure how widespread that is.
I'm really seeing that this bill's probably more needed when we're in more of a distress time than probably now. Would you agree? Because when there's, this is probably mainly distressed property. You would probably see your case numbers go up. But have you seen, or have either, any of the groups out there seen anybody where there was money that was paid and there was fraudulent activity, where someone lost money? I understand someone trying to sell the property, thinking they're gonna sell it, gotta pay a couple payments or whatever the situation is. They're upset they didn't get the contract sold. But is there any actual monetary loss outside of that angle that's happened?
Yeah,
No.
Yeah, I think right now you're seeing, particularly at the KREC level, they're probably not having these complaints because it's dealing with people who are unlicensed. And I think that the way some of this wholesaling would work is that you have somebody who is in between, and so they're motivated to get an increase in that price, but maybe not share in all of those riches with the person who they're buying it for often for a set price. When you're a real estate licensee, which is different than being a realtor, I'll point that out. I think that there's been some differences in that discussion. When you're a realtor, you're a member of the association. You're also adhering to certain codes of ethics and certain other types of business practices that make sure, in addition to what's in state law. Now, state law, you're still advocating on behalf of your client, and you have an obligation to do so. When you're a realtor, there's also additional responsibilities and adherence to a code of ethics that requires a lot more training and a lot more practices that are dictated by being a member of that association. So there's some distinctions there that are not being followed by the people who are involved in this line of work. And I think that gap, it's like certainly real estate professionals have an interest in getting the best price, but in the cases in some of these wholesalers, they're enjoying a lot more of that rewards than the actual person who is selling that property.
Okay. Other questions, comments? Not seeing any? Thank you, Mark. Are there any neutrals? Any opponents? We'll go ahead and close the hearing on 213, and we will open the hearing on 2112. Chuck, you want to give us an overview?
Thank you, Chairman, members of the committee. House Bill 2112 deals with self-storage rental units. And the bill does three things. First, with respect to claims or actions against operators of self-storage rental units, it limits the value of the property in a claim for damage to property or loss of property. It limits the value of the personal property in such a claim to the maximum value of the personal property permitted to be stored in the lease space under the terms of the rental agreement. That's on page 1, lines 13 to 18. The second thing the bill does is requires that rental agreements include a question whether the occupant wishes to designate an alternative contact for purposes of notice. And that's on the bottom of page 1 of the bill. The third thing the bill does is permit online sales in a situation where there's a default and the operator wishes to sell the property. Online sales can be conducted online. There is a provision that pertains to advertisements for such sales on the bottom of page 2. Under current law, the advertisement for a sale must be in a newspaper. The bill permits it the advertisement to be done in any other commercially reasonable manner. There's also a provision that if less than 3 independent bidders attend the sale in person or view the sale online at the time and place advertised, then the manner of advertising the sale is not going to be deemed commercially reasonable, and the sale has to be canceled, rescheduled, and re-advertised. So that is essentially what the bill does. This bill is substantially similar to House Bill 2454 from last year, which was went through the House Commerce Committee and was passed by the House 114-9, and then died in on the Senate side. There are some differences between that bill and this bill. The alternative contact provision was not in 2454, and the language on the bottom of page 2 is a little bit different in the bill from last year. And that is what the bill does.
Senator Peck, did you have something? Are you missing the packet or something?
Yeah, Mr. Chairman, the bill we're looking at is 2112, but the bill that I have in my packet is 2212. That has to do with alcohol, so I was immediately an opponent. No, okay.
I'll go down.
Okay, but I just thought that for the benefit of committee members.
Yeah, we got the wrong bill in there, don't we?
I was trying to follow our revisers.
Why don't you run downstairs and get the right bill? And do we have any questions for Chuck? And then we'll go ahead and Senator Stephan.
Chairman, well, I think I was hearing the same bill I was looking at. Hey, on that bottom of that page 2, that commercially reasonable manner, I'm sure a lot of thought was given to that as y'all wrote this initially. And it looks like you landed on just defining it by having 3 or more bidders at the subsequent auction. That's a very, very interesting way to come to that definition. Help me understand the legitimacy of that definition, or what might be a more appropriate definition of commercially reasonable manner. Thank you.
Senator, yes, that's a good point. That is indeed sort of in an unstated way how commercially reasonable is defined in the bill. And certainly if the committee's wishes to add a definition of commercially reasonable that is more precise, then that could be done. I'm not sure that there is particularly an issue with the language, unless, of course, the committee wants to be more precise about how commercially reasonable should be defined.
Go ahead, Senator Stephan.
Just flesh that out a little bit more for everybody. 'Cause it used to be you had to advertise in a newspaper. They wanted to move away from that, but then they failed to provide any other clear avenues by which anybody needed to advertise. Is that correct? Is my statement correct?
Yes, Senator. Commercially reasonable is not defined more precisely than sort of the implication that, or actually the fact that if 3 people don't attend in person or view the sale online at the time and place advertised, then it's not going to be deemed as commercially reasonable. The sale has to be done again. But as you point out, that is the only manner of defining how the sale is to be advertised, but, you know, with respect to an online advertisement.
Go ahead.
Okay, and I'm not finding it. This says 3 people have to be present, or 3 actual bidders have to be present?
Yeah, I'm sorry, Senator, I misspoke. You're correct. This specified language is 3 independent bidders.
Oh, okay, where is that?
That is on line 39 on page 2. line 38 and 39 on page 2.
Doesn't seem to be on my copy, but,
We're gonna get some copies up here. Michael wants to get them, so.
okay. But, okay, hit me with one more time with what it says.
Senator, the language is such, and I'll start with sort of the beginning of the sentence that references it. Such advertisement shall be in the classified section of the newspaper if notice is placed in the newspaper. If less than 3 independent bidders attend the sale in person or view the sale online at the time and place advertised, the manner of advertising the sale shall not be considered to have been commercially reasonable, and the sale shall be canceled, rescheduled, and re-advertised. Further notice to the occupant shall not be required.
We'll get the copies of the bills. We're gonna go ahead with the hearing, though. We've got the sup note there from what happened in the House. Let's go ahead and have Whitney Dameron testify.
Thank you, Mr. Chairman, members of the committee. I'm Whitney Dameron, appearing on behalf of the Self-Storage Association. With me today is Paul Davis, who also represents the association. Self-Storage Association is a national trade association with members in the self-storage business in all 50 states. Those of you who were on this committee last year may recall that we had a similar bill that came over from the House. Had a relatively strong vote back then as well. This one passed the House 120 to 5. And some of the issues that Senator Stephan raised, we looked at and worked to address. We worked with the reviser. I know Mr. Reimer and I talked about, that kind of an issue and how do you define what is commercially reasonable, and I'll get into that with my testimony. Our bill before you does make 4 changes to the Self-Storage Act. In Kansas, the National Association, they come up with things that are kind of industry standards. A lot of their members are multi-state, and so they like continuity with jurisdictions, and so they'll come into 3 or 4 different states around the country every year and try to level out the laws, and that's kind of what we're seeing here. We started the process last session and continued on after the session was cut short last year. So the first issue highlighted in the bill, make damage loss limitations in contract enforceable in law. So typically, if you rent a self-storage unit, the contract will say in it, I do not want you to put more than X amount of value, $5,000 worth of stored items into my storage unit. There have been some jurisdictions that don't enforce that in a court of law, absent some kind of a statutory protection. The reason the self-storage operator might want to limit the value of items in a storage unit is people know when things are stored. People talk to their neighbors. I have my gun collection, my gold bars, my coin collection, my antique car. Those kind of self-storage units aren't set up to provide security like a safe deposit box or for items that are valued in the tens of thousands or hundreds of thousands. They have security based upon household items that people typically store in a storage unit. Similar legislation has been passed in the majority of states around the country, including all 4 states around the state of Kansas. The second one is third-party notification of a potential default of a contract. You stop paying your bill, self-storage operator sends out the appropriate notices through first-class mail, email, telephone calls. You're getting to the point that items are going to be put up for auction to satisfy that bill. Last session, members of this committee, Commerce Committee, said, wait a minute, what if someone gets moved to a nursing home? They don't get notice. Someone is deployed in the military. That information wasn't necessarily accurate in the way the industry works. And I do want to clarify that issue in regard to, for example, military. Self-storage operators under federal law cannot sell anyone who's in the military's items. So that is not an issue. But we said let's work and put something in statute that helps in those kinds of rare instances where you can't get a hold of the person, or the person doesn't want to be contacted who is renting that unit, and that is, we'll put in Kansas law that the contract must provide for the ability of a renter to designate a third party to be contacted if they can't be contacted. So we put that in our bill. That is unique to Kansas, so it's not really a national trend. It's just an additional consumer protection opportunity for a person renting a unit. They don't have to do it, but if they want to put down their neighbor, their brother, their cousin, or their lawyer, or anyone else, they can do so. The third issue that we have in our bill has to do with allowing auctions to be conducted online or in person. That trend has been continuing even pre-COVID. These auctions were going online as a way to attract more people to look at items. There are websites that are geared up to find a storage auction in my neighborhood. If you Google that, it'll ask you for your city or your zip code, and it'll just start sending you all kinds of auction things, just like a yard sale or anything else similar. That kind of language has been approved in a majority of states, again, including all 4 states surrounding the state of Kansas. The public notice sale of auction. So as we've talked about, and Mr. Reimer talked about, in current law, you want to go to an auction because the person is not satisfied with their contract, and you have a right to sell items and satisfy your bill. Current law says you put an advertisement in your newspaper of local jurisdiction. Trending in other states, obviously, newspaper circulation is down. Newspapers are not free, even online. There are paywalls. I know I talked to this committee last year before I finally gave up my daily delivery of the Kansas City Star. My annual bill for home delivery was $1,300. They're pricing themselves out of the market. Capital Journal here in town is over $500 a year. Obviously, it's cheaper if you go online, but I defy most people to find these kinds of ads online. You have to click through and really want to go find that to get into the legal notices, get into the advertisements, and so forth. The industry is trending away. Again, these websites that people go to for finding these auctions, the self-storage facility itself posts things on their website. Quite frankly, what they do is that they take names from people who are interested in these auctions. When they have an auction, they send out the blast email. We're having an auction second Saturday of the month of April. Come on out to this location. The statute only says that the advertisement in the newspaper discloses the time, the place, and the terms of the auction. There's nothing in statute that says you put the name of the person who rents the unit. So the advertisement in the newspaper is not about notifying the person who's rented the unit that we're going to auction your stuff. They get noticed through first-class mail, through email, through telephone calls, and so forth, as provided under contract and in statute. In statute says first-class mail and electronic notification if they provide their telephone or their email. In this day and age, you might move, you might have a change of address. Most people are keeping that cell phone no matter where they're moving in the country. They're keeping that email no matter where they're moving in the world. So people are getting this kind of notice. We got into the issue of, because the way we defined it in the bill was any commercially reasonable manner. We had that in the bill last year. Questions were raised by the committee. What does that mean? How does that work? Well, how it works in our day and age is if someone complains, so someone had their items auctioned, they felt that it was auctioned in some manner that was not commercially reasonable, that would be determined in a court of law. It's where these kinds of issues are resolved. So the judge, whether it's a small claims court or limited action district court, would look at the circumstances, and that judge would be the determiner, or potentially a jury. This kind of an issue probably doesn't get to a jury, but they would take into account what did you do to advertise your auction, how did you get people there, and that's typically how these kinds of things work. It's determined in the court of law. But in order to provide some kind of standards. We said, okay, let's put a standard in here that essentially says the proof is in the pudding. And that meaning you got to get 3 people to show up to the auction and bid, either online or in person, register as bidders, or it's not a valid auction. And so that was our attempt to provide some kind of a standard on what is a commercially reasonable auction. Auctions today, there is no minimum requirement. You can have 1 person show up or no one, quite frankly. But we did put the standard in of 3 bidders on their own accord. That kind of language is found in law in 17 states. There are 3 states that have no publication requirements whatsoever. There's 5 states that have limited publication. Again, the industry is trending away from newspaper publication and into these kind of other kind of marketing, whether it's Craigslist, Facebook, other social media, direct mail, Twitter, and the like. And so those are the changes that we have brought to the Self-Storage Act in Kansas, and would be happy to stand for questions at the appropriate time, Mr. Chairman.
Do we have any other proponents? Are you speaking, Paul? No. Questions? Do we have any questions? Senator Allen.
Thank you. Whitney, thanks for being here this morning. So just not so much really having anything to do with the bill. I'm just kind of curious because we see bills that come through the legislature that are pre and now during and post-COVID. My question to you is that what types of trends are you seeing in your self-storage industry, specifically consumers who were using those units? What has COVID with, obviously you got more unemployed or underemployed people. My guess is you probably have more people moving about, maybe regionally in the country, I don't know. I'm just kind of curious, just from a purely a consumer perspective, what has the owners of these units been seeing during COVID and as we start to transition out?
I have a good friend in town. He's a neighbor, and we spend a lot of time shooting together. Valley Self-Storage here in Topeka. We talk about his industry quite a bit. He's not seen significant increases in volume. So he's not seen significant transition from people moving in, moving out. Business is pretty consistent. I think actually what you're seeing is more people building self-storage. You're probably seeing in your community, I know over in Lawrence, they've had some expansion. Specific to COVID, what he has done most recently is retrofitted 2 of his self-storage units in town to have automatic locks that are accessed by a smartphone, and it's doing 100% touchless renting of a unit, providing someone with a code for their smartphone where they show up, they get through the gate with a smartphone, they enter their unit with a smartphone, and those kinds of things that the public is demanding. But as far as increased utilization of self-storage, I don't know that I've seen that.
Have you seen like an increased default in contracts, or has that all been pretty consistent as well, too?
Yeah, it's been pretty consistent.
Thank you, Mr. Chairman.
Okay. Further questions? Okay. Senator Peck.
Thank you, Mr. Chairman. So currently, doesn't matter how many people show up for an auction, if I heard you correctly.
Correct.
And the number 3 was simply put in there to satisfy the press or the newspaper association.
I don't know that satisfied the press. You know, we offered that in the spirit of compromise. People said, well, this is something new, it's different. We're having a hard time defining what, or coming to terms with what that standard means, any reasonable, commercially reasonable manner. So we said, okay, we'll define it, that it means at least 3. Typically, these auctions have 15, 20 people. I mean, there's reality shows, Storage Wars, that's increased the popularity, and so self-storage units are getting calls, say, hey, put me on your list for your next auction, I want to come see what these are like.
Okay, well, I understand that, and I agree, newspapers are becoming a dinosaur, no disrespect to newspapers, but I just was, I don't know that the 3's necessary, but I'll just leave that up to the committee. Thank you, Mr. Chairman.
It was raised on the House side, and there were some who offered to take it out, and I said, I'll remain silent on
Thanks, Whitney. We'll go ahead and move to the opponents. Emily Bradbury.
Thank you, Mr. Chairman and members of the committee. My name is Emily Bradbury, and I'm the Executive Director of the Kansas Press Association, which represents approximately 200 daily and non-daily newspapers across the state. As my written testimony details, we respectfully stand in opposition of House Bill 2112. We are concerned about the lack of definition of commercially reasonable manner, and by removing the requirement for publication in a newspaper as the official notice. As I mentioned in my written testimony on the latest study in 2021 of the Kansas Readership Study, 8 out of 10 Kansas adults read and access news and information from a local print or digital version of a newspaper. And over 76% of Kansans look to their local newspaper for public notices, and overwhelmingly want to view notices in their local newspapers where they're easy to find, rather than having to continually scan dozens of websites for their notices. There has been a 41% increase across publication eyes on our publications since the start of this pandemic. We realize that the notices mentioned in the bill include a cost, but that cost can be recouped from the proceeds of the lien sale. The average price is often small, with a recent public notice in the Topeka Capital Journal that included 9 different storage units, and the cost to advertise that sale was only $20 per unit. We ask that the committee leave the current notice requirements as is and require publication in the newspaper. If a storage unit wants to also choose another commercially reasonable manner to get the word out, nothing keeps the owner from doing so under existing language. Many of them already supplement newspaper notice with social media posts now. We believe that the cost of a notice is a small price to pay for transparency and proper notice. In the end, this is about the potential taking of someone's property. We believe strong consideration should be given to making sure that doesn't happen in the dark. For us, this is a transparency issue that protects both the owner and the renter. And I thank you for your time, and I stand for questions.
Questions? Sarah Holland?
Hey, Mr. Chairman, but just so I understand, on this notice, they are not required to list the owners of the contents who are being sold, correct?
Correct.
Okay. So how does that square with your previous statement?
We often see them list the name. How often that happens, I'm not sure, and I can get back with the committee chair, but we often see that the public notice does include the name, because I think they have a vested interest in trying to find this owner and try to recoup the monies.
Understood, but just so I understand, you're fine with the language as is if it doesn't list the owners, but just that they have to notice that the sale is going to happen, correct? Correct. Okay, thank you, Mr. Chairman.
Other questions? Senator Schramm.
Thank you, Mr. Chairman. I think we're all aware that newspaper subscription rates have drastically declined over the years. And is a person required to have a subscription to the newspaper in order to view these public notices in an online public newspaper?
They are not. They are, the industry standards of that is before the pay law.
Thank you.
Other questions? Okay, not seeing any. We'll go ahead and close the hearing on 2112. Thank you. With that, we'll be adjourned until Monday. Like I said, we will start the hearing on 2197. That's the unemployment bill. And we'll see what the House did with their 22 amendments. And then it's going to be all next week. So if you have amendments as we move forward, you probably want to get to working on them, because we're going to put them on or attempt to. And we're going to finish that bill hopefully by the end of that week. So, Senator Tyson, you got a question? I'm planning Monday through Friday, or Monday through the end of the bill. And it seems like we never get to Friday. So let's try not to get to Friday and have a fun day on Friday. So.